All right. Good morning, everyone. I think it's 11:01, so we'll get started. We definitely have a full agenda here today. So welcome. Great to have you all with us, and welcome to From Stigma to Strategy, Navigating Mental Health and Employment Law. My name is Elizabeth Johnston. I'm an attorney in Verril's Employment and Labor Group, and I'm joined by Erik Peters today, who's a partner in our Employment and Labor Group. And today we're going to be talking about what employers need to know about compliance responsibilities related to employee mental health, give you some actionable tips and guidance, both to respond to these issues and help develop a supportive environment for your employees that might be experiencing these issues. So a couple quick notes before we get started. For those of you who aren't familiar with our webinar series, it will be recorded and emailed to you after the session along with copies of the slides. This webinar has been approved for 1 CLE credit for attorneys and 1 SHRM credit. And if you're an attorney, we'll be submitting your name to the main bar for that credit. And we'll also be emailing certificates for your records or the SHRM certificates for your records. If anyone has questions during the presentation, please feel free to enter them into the Q&A box, and we'll do our best to answer them as we go through the content. Otherwise, if we have time at the end, we might address some at that time as well. So with that, we will get started. Next slide, please. So I want to start out with a couple of statistics that I think help demonstrate why we're talking about this issue. And this isn't the first webinar that we've done on this topic this year because it is becoming such a prevalent topic. And I know my discussions with my employer clients and Erik, I'm sure as well. But according to a 2023 State of Mental Health in America study, 21% of US adults are experiencing a mental illness. That's nearly 50 million Americans. And Maine actually falls right about in the middle of those rankings. About just over 21% of Mainers are experiencing mental illness. And I think that this is sort of a startling number because the conversations about mental health have sometimes been things that people shy away from or don't like to discuss with others. But I think this really demonstrates that it is a prevalent issue. I think it's also important to understand sort of how this plays out among age groups as well. Adults age 35 to 44, which is a predominant section of the workforce, we've seen a huge increase in mental health reports from 2019 to 2023. And there's certainly some evidence to support that COVID had something to do with that increase. COVID has been linked to significant increases in depression, anxiety among adults, as well as younger adults as well, with 50% reporting mental illness in 2023. So I think the takeaway is that, if this is something you're experiencing, you're not alone. If you know anybody with a mental illness, chances are you probably do. Chances are that people in your workplace, your employees, are experiencing these issues. And so I think it's important to be something that we're thinking about in terms of how to address. Next slide, please. Another, I think, really interesting piece of this is that most or almost most adults are not receiving treatment for mental illness. We talk about those really significant numbers of folks experiencing issues. But according to a study from a couple of years ago in 2021, less than half of adults with a mental illness were receiving treatment, and 2/3 of those adults with a serious mental illness were not receiving treatment, or were receiving treatment. I apologize, my double negatives there. But that's a significant number of folks who aren't seeing a therapist or addressing these concerns. And there's ripple effects to this. Substance use is higher among folks with mental illness. Rates of unemployment are higher. So again, just more reasons to be talking about this now in terms of these current issues. Next slide, please. So in addition to understanding this on a human level, so to speak, there's also economic implications to this increased prevalence as well. So these are statistics from 2010, which estimated that worldwide between 2.5 and 8.5 trillion dollars are attributable to lost output related to mental illness and other related disorders. This is due to folks having diminished productivity at work, people not participating in the workforce. I just mentioned sort of the higher rates of unemployment, at least in the US, among folks in this population. Increases in healthcare expenditures. And this is obviously a really significant global figure, but for those of you who, within your own organizations, I'm sure can see the economic effect of this as well. If employees are unable to work due to mental illness, that has a dollar amount tied to it in some cases. Your positions might remain open depending on unemployment rates in your area. Employees just not working as efficiently or as effectively. So hopefully today, some of the discussions we'll have will help remedy those issues for your bottom line as well. Next slide. With that, I will turn it over to Erik.
Thank you. So as Liz mentioned, as you can gather from the title of this presentation, one of the reasons that we're doing this, and one of the reasons that we felt there is a need, and people have asked us to do this presentation, is because people are talking more about mental illness. It's become less stigmatized. And one way that that happens, especially in Western popular culture, is celebrities talk about problems and things kind of come out of the shadows. So these next couple slides, some of you will probably be familiar with the figures on them. They're celebrities, sports figures, people in pop culture who have talked about their own challenges with mental illness or done work to try to destigmatize mental illness and change the conversation around it. So Prince Harry, probably best known recently for the falling out with the rest of the royal family that he and Meghan Markle have had. Prior to that, actually, he and his brother, Prince William, founded an initiative in the UK to tackle stigma and change the conversations on mental health. And for both of them, a big part of it was what they endured when their mother, Princess Diana, was killed, as we all probably remember, in a car crash when she was being chased by paparazzi. And that happened back when he was 12. So Leah, if you could move to the next slide. Another example that you may have seen recently, those of you who watched the Olympics, Caleb Dressel had an amazing 2020 Olympics. And then a couple of years later, stopped swimming, pulled out mid-event during the World Championships in 2022, and took a significant amount of time off while he was dealing with mental health issues. Came back and participated in the Olympics that just concluded a couple months ago with 2 golds and 1 silver. If you can move to the next slide, kind of staying on that theme. I'm sure a lot of you recognize Simone Biles from this slide, and you may have heard, those of you who watched the Olympics or watched actually the run-up to the Olympics with our gymnastics teams, prep and trials for the competition to who would actually make the team. That's actually Simone Biles pictured with Beacon, who is one of many emotional support dogs that the U.S. Olympic and Paralympic Committee and USA Gymnastics in particular made available to athletes while they were competing to actually provide comfort and support to them during their competitions. And Beacon, this dog you may have seen, he actually got a lot of airtime. He actually had a lanyard made up for him that described his title as Goodest Boy. And one other recent celebrity or person in pop culture, actually more in politics, Leah, if you could go to the next slide, please. Yadira Caraveo, who is a U.S. representative from Colorado. Her district includes Fort Collins, where I believe Colorado State is, and also part of Boulder. She's a physician. She's actually a pediatrician, or was a pediatrician before she got into politics. And that up there is a statement she put out after she was hospitalized for treatment of her depression at Walter Reed, the medical center in DC. And some of you those of you who follow politics may also remember John Fetterman, who is a US Senator, sought treatment there for depression that he was suffering from after he suffered a stroke while he was running for office back in 2020. You may, if you don't recognize John Fetterman's name, you may know him if you see him. He's the only senator who's 6'8" with a shaved head who wears Carhartts regularly. So let's go on to the next slide. We're going to talk a little bit about increases in workplace discrimination claims, especially claims alleging mental health discrimination. So you can see here that the amount of ADA, Americans with Disabilities Act related charges in 2021 related to mental health discrimination went up 10% from 2010, and with anxiety claims and PTSD claims being the most prevalent of those. Liz mentioned earlier the effect of COVID, the pandemic, on people's mental health generally, and on mental health and what's widely believed to be mental health claims in general. Let's go to the next slide. Consistent with that, our friends at the EEOC, and for those of you who don't speak jargon or alphabet soup related to employment law, the EEOC is the Equal Employment Opportunity Commission, along with our friends at the Maine Human Rights Commission up in Augusta, the MHRC. The EEOC enforces federal anti-discrimination law. The MHRC enforces Maine state anti-discrimination law, the Maine Human Rights Act. This is an excerpt from a document that the EEOC put out earlier this year that detailed their strategic enforcement plan for the next 4 or 5 fiscal years. And the excerpts here, you can see that they're explicitly stating that they are going to be going after or using as an enforcement priority workers facing mental health related disabilities and discrimination against them. And they are considered, that group of individuals and those workers are considered to be what the EEOC refers to as a category of vulnerable workers when it comes to employment discrimination. So if you're listening to this, if you're participating in this webinar, you're probably of a mind to consider compliance issues and act proactively. So we've given you a couple reasons why you should. 1, your economic bottom line. 2, the amount of claims are increasing. And 3, the government is coming after people who don't treat this as a priority, this type of compliance with the law in this area as a priority. So all good reasons why you should listen to what we're saying and hopefully take some of it to heart. We're going to move on to the next slide, and Liz is going to talk a little bit about employer responsibilities and what the Maine Human Rights Act and the ADA both require and prohibit.
Yeah, thanks, Eric. So we'll jump right back into that alphabet soup, so to speak, with ADA and MHRA. So as Eric mentioned, ADA is the Americans with Disabilities Act, and the MHRA is the Maine Human Rights Act. And what you need to know about these for purposes of this presentation is that both of these laws protect individuals with disabilities. So they offer sort of 3, I think, main categories of protection. 1, under both laws, employees with disabilities and applicants are protected from harassment and discrimination from others on the basis of their disability. And essentially what that means is that employees and applicants can't be treated differently or less favorably just because they have a disability. So employers can't decide not to promote somebody because they have a disability, decide not to hire somebody because they have a disability, or if the employer thinks that'll be difficult for the position. Employees are also protected from harassment on the basis of a disability. So in the same way that the law provides that employees can't be sexually harassed or harassed on the basis of race, that also applies in the disability context, both physical and mental disabilities. The other category of protections is employers are required to reasonably accommodate employees and applicants with disabilities. So that applies both throughout the application process. If an applicant requests some change to the hiring process, to the application process, in order to enable them to participate in that, under these laws, the employer has a duty to accommodate that. Likewise, for employees who are on the job, have been hired, and might need some adjustment to the workplace, and we'll talk more about this in depth later, but might need some adjustment to the workplace to allow them to do their jobs. The MHRA and ADA also prohibit employers from retaliating against disabled or employees or applicants with disabilities for requesting a reasonable accommodation. So if an employee or an applicant makes that request, the employer can't take adverse or negative action sort of in response to that request for accommodation. And next slide, please. So I think that brings us to one of the significant questions of the day: what does it mean to have a disability? There are a couple of different ways that employees constitute an employee with a disability under the ADA and MHRA. And I want to talk about those with this slide. So the first is an employer and applicant is considered to have a disability if they actually have sort of an active impairment right now that substantially limits one or more of the individual's major life activities. And we'll dive in a little bit later to what specifically that means. But in other words, they have a disability right now. The other way an employee can be protected under these laws is by having a record of a disability. So a record of maybe a past mental illness, mental impairment, physical illness or impairment. That's also going to trigger protections from the ADA and the MHRA. A third reason that an employee is protected is being regarded as having an impairment that would constitute a disability. So if an employer believes that an employee, and I'm going to refer to employee, but I've talked about how this applies to applicants. But if an employer believes that an employee has a disability or an impairment, that can be sufficient to give protections under the ADA and the MHRA. And this one's especially tricky in the mental illness area, I think, where somebody might make an assumption that an individual's, dealing with a certain illness or an impairment and assume that they're experiencing one of those struggles. And even if they don't make that clear to the employee or the applicant, if there's a record that the employee is perceiving them as having a mental illness or impairment, that can, again, be sufficient to trigger protections from harassment and discrimination and other requirements under the law. Another category where employees are protected is called associational, having associational coverage. So if an employee or an applicant is associated with someone who would otherwise be protected under the Maine Human Rights Act or ADA, let's say someone with a disability, they can also be protected under the ADA from adverse actions related to that perception. So for an example, if an employee has a child with a disability, the employer can't discriminate or harass that employee just because they're associated with somebody with a disability. As an example, there was a case a few years back where an employer terminated an employee whose child had significant medical issues. And the child's condition had worsened, and the employer was worried about how that would affect the cost of health insurance and health-related costs for the employee's insurance coverage. And based on the circumstances of the termination, the court found that that was discrimination because the employer was taking unique adverse action against this employee just because they had an association with somebody with a disability. So I think it's important to be aware of that category, even if it's not a direct, sort of connection with the employee in terms of dealing with a disability. With that, we'll go to the next slide, please. So in terms of mental impairments, we'll talk a little bit more today about what that might mean, sort of in the mental disability arena. the federal, or sort of the definition of what a mental impairment as a disability is very broad. So it's an intellectual disability. It could be an organic brain syndrome, an emotional or a mental illness. I think those are the terms that we're most used to hearing, as well as learning disabilities that might impact an employee in the workplace. Next slide, please. But regardless of what type of disability the employee is experiencing, the diagnosis of it is not in itself enough to constitute a disability for purposes of ADA and MHRA protections. There is a requirement that the impairment must substantially limit one or more major life activity to qualify as a disability. And that's not, again, the word substantially suggests it's not just sort of a minor affect on a major life activity, and Erik will talk a little bit more about what this means, but a substantial limit to it in order to actually constitute a disability for purposes of these protections. I think we'll turn it over to Erik to talk a little bit more about what those limitations mean.
Thank you. Yeah, so as Liz just mentioned, you don't qualify for the ADA or the MHRA's protections automatically just because you have a particular diagnosis. And, it's beyond the scope of this presentation, and, we don't want to send you to law school or employment law school, but the way that the ADA and pretty much the MHRA work is the standard is for being judged or determined to be disabled and therefore entitled to the protections of those laws. It's not a particularly high bar to meet, but you do have to meet it. And so, as we've been talking about, you have to show, if you're bringing a claim, that there is a major life activity that your mental impairment substantially limits. And so what we've got listed here on these bullet points are a lot of the ones that you see or that you would think would be implicated if someone had a mental health issue in terms of a major life activity that they couldn't perform. I'm schizophrenic. It's difficult for me to concentrate. I'm a sociopath. I can't interact with others. We'll go into examples of mental health conditions that might be disabilities in just a second on the next slide. But these bullet points here are kind of common major life activities that you would see implicated in a mental health related disability claim. The last bullet, I'll just say one thing briefly before we go to the next slide. Regulating thoughts and emotions. There's sort of a controversy, I guess is maybe the best way to put it, over whether with regard to regulating thoughts and emotions and the ability and also interacting with others, whether not being able to get along with people can constitute a major life activity. I've seen cases both ways as to whether that will suffice to get you into the category of disabled. But that's one that comes up because, as any of us who've dealt with somebody who has a mental health issue, it's often difficult for people with a condition to regulate their thoughts or emotions or to deal with other people. So Leah, if we could go to the next slide, and let's look at some of the conditions that are often used as the basis for a disability claim. As you can see, anxiety is on there. That is a big one. These other, kind of social phobias, postpartum depression, obviously, a pregnancy-related or post-pregnancy related condition that can also implicate the Pregnant Worker Fairness Act that was recently passed. Panic disorders and OCD. Panic disorders and anxiety disorders, just sort of anecdotally, along with PTSD, are probably the ones that I see in my practice, along with depression, that make up the bulk of the claims for mental impairments that serve as disabilities. So let's go to the next slide and let's talk a little bit more about this concept of, you have to show more than just a diagnosis and the substantial limitation on a mental, on a major life activity rather. So you can see here, these are a couple of cases that we pulled and put on here where people didn't meet this standard. They had the diagnosis, but they didn't, even with what I referred to as a relatively low standard, they didn't complete the second part of the equation in showing that there was a substantial limitation on an ability to perform a major life activity. Tinsley case, even though you have PTSD, you're not disabled. Weaving, ADHD, but you're not disabled. And Russell, even though you have depression, you didn't show the ability to a limitation on ability to perform a major life activity. And that's significant because it's obviously, that's what you have to show, as we've indicated, to be entitled to the protections of the statute. Leah, if you could go to the next slide, please. We'll kind of pivot a bit and talk about why it's difficult for employers both to sort of immediately address these problems and then deal with them on an ongoing basis. So it's not, and those of us who've had issues or have had friends or family members rather who've had mental health issues know that it's not linear. It's not like recovering from a broken ankle or a knee surgery or something like that, where there's a recovery, and as time goes by, you sort of automatically get better if you're doing the things that you're supposed to be doing to treat your physical illness. Mental health issues and mental impairments don't always work that way. They don't have to be permanent in order to be substantially limiting and therefore to get you coverage under the ADA or the MHRA. As you can see, an impairment that's episodic or that goes into remission can qualify as a disability for purposes of what we're talking about here if it substantially limits a major life activity while they're active. And you can see at the bottom of the slide, we've got some citations to USC, refers to the United States Code. That's the federal law, the ADA itself. CFR stands for Code of Federal Regulations. Those are actually regulations that the U.S. Department of Labor has put out to help enforce the ADA. So the key takeaway from this slide is that while symptoms can be episodic, what you need to focus on for determining whether an employee is disabled, what we look at as lawyers is how limiting is the condition while the symptoms are present. So we're going to go from there to talk a little bit about the disabled employee's need for an accommodation. And we're going to start at sort of the beginning here, which is what the law refers to as an interactive process. So we've talked about a little bit about the employer applicant has to be a qualified individual with a disability requesting an accommodation. Okay, so where do we go from there? Where we go is that the employee and the employer have to engage in what is legally described as an interactive process, which is just a really fancy way of saying that they have to communicate with one another to determine if there is a reasonable accommodation, and we're going to talk about what that means, for the disability that the employer can provide without experiencing an undue hardship. And those of you who've dealt with ADA cases or who have dealt with Maine Human Rights Act cases that involve disabilities are familiar with all of these terms. Physical, mental impairment, it's the same thing. But again, with the prevalence of mental health related issues and these things coming up more often, it's really important to focus on what exactly you need to do with regard to the interactive process, because we see a lot of cases that essentially stem from a breakdown in the communication between the employee or the applicant and the employer about what a reasonable accommodation for the alleged disability might look like. And so let's start at the very beginning. Typically, the way that an employer, something like this is implicated, is that the employee says, hey, I'm having, they're not going to come to you and say, I am a qualified individual with a disability. Please, let's engage in the interactive process. They're going to come to you and say, I'm having a problem. I've got symptoms of depression. I've got crippling anxiety. It's hurting my job performance, or the reason that I'm having, you come to them with performance issues and they admit it and say, hey, I can't do the job, or I'm having problems doing the job because of X, Y, or Z. But that's the kind of thing that puts you as an employer on notice of the potential need for accommodation. There are other ways in which you can find out, and we'll talk about that in just a second. But it's basically that is normally what happens is the employee says, I need help. I need something to help me do my job, or the applicant says, I need help in applying for work with your company. So the sort of the genesis of the obligation to begin the interactive process, employer knows the employee has a disability or has reason to know that the employee's workplace problems are related to the disability. That has reason to know language that's in those second and third bullet points on this slide. That's what the law refers to as constructive knowledge. Hey, I'm not telling you that I'm disabled, but with everything, all the circumstances that are surrounding me, you should know. So it's, the employer knows or has reason to know that there's a problem because of the disability, or the employer knows or has reason to know even that the disability prevents the employee from requesting a reasonable accommodation. So you can think that if you have somebody who's spiraling due to depression, who's having an acute episode of PTSD, who's schizophrenic, I can't tell you that I need a reasonable accommodation because of my condition. There are certain circumstances under which an employer is charged with that knowledge anyway. So if we go to the next slide, let's look at some examples from case law that talks about this. So it's, I talked a second ago about the contrast between mental health related disabilities and physical ones in terms of recovery. If you see me coming in, with a cast on my leg and crutches, or I'm hobbling around, and I can barely walk, you're like, oh, I guess he broke his leg skiing, or I guess his bad back is flaring up. Mental health related stuff isn't always like that. So we talked about this concept of constructive knowledge a second ago. How can you become aware? How can an employer know or should have known about a disability? Indirectly, this Bodie case, through observation of the employee's behavior. And that, I think, is probably the big one here. Seeing that there's something wrong with the employee through your everyday observations of them. Another one can be a diagnosis, a treatment plan, or sort of semi-related severe symptoms or work restrictions. That can tell you somebody has a disability that you may need to start the interactive process about reasonably accommodating them. And then in the Hedberg case sort of builds on that and says, hey, if the symptoms are so obvious, you can't stick your head in the sand, employer, and pretend you don't know. All right, we're going to go back to Liz for just a second. She's going to talk a little bit more about the employee communicating to the employer about its need for a reasonable accommodation and the interactive process in general.
Definitely. So, okay, perfect. So getting into the interactive process, often a question that comes up is, how do we know what the accommodation is that's needed? How do we verify that this individual has a disability? Maybe you have somebody coming in and requesting a variance to their schedule or some other accommodation, but it's not entirely clear to you why they need it, or if there's, adequate support for that accommodation, especially if this is going to be something that might be difficult to provide. So employees do have an obligation to provide enough information to an employer to sort of engage in this reasonable accommodation process. They need to establish two things. One, that they have a disability that requires accommodation. And two, they need to provide enough information about the functional limitations that disability or that condition is causing to enable the employer to help identify what a reasonable accommodation could be. Excuse me. And in the mental health arena, we often see that this documentation comes from maybe, the individual's standard healthcare professional, a PCP. It might be a psychologist. It might be a psychiatrist. It also could be a counselor or a sort of a social worker or any sort of licensed mental health professional as well. It's also tough in the mental health arena because, unlike physical disabilities, these aren't always obvious. Sometimes, or, if you have an employee coming in with a broken leg, it might be pretty clear that they need an accommodation related to walking or standing or sitting or something like that. You might not need, additional documentation for that disability. But for mental health concerns, it's not always as clear what employees are dealing with and what they might need to help them better address those issues at work. So we do see situations come up pretty frequently where employees haven't produced documentation, or in some cases haven't produced sufficient documentation to support that they have a disability or that they need an accommodation. So in those cases, employers do have some recourse to, go back and request that the employee provide additional documentation, again, to identify those two factors. Do they have a disability, and what are the limitations needing an accommodation? But employers also do have the ability to potentially communicate directly with a healthcare professional with appropriate waivers from the employee, or even to require the employee to see a physician or a healthcare professional of the employer's choice. Again, if they're just routinely not engaging in that process by producing the documentation themselves. And one thing I would note with respect to the employer requiring an employee to see the employer's choice of a healthcare professional, it doesn't mean that the employer has received unfavorable information or information that they don't believe or sort of are questioning the legitimacy of on its face. It's rather that the individual or the employee has provided insufficient documentation. In other words, their healthcare professional is not, affirmatively identifying that they have a disability or providing that information that allows the employer to, again, engage in that reasonable process about what a reasonable accommodation might be. And next slide, please. Okay. So one of the terms that we've used a few times today is a qualified individual with a disability. And this is backing up a little bit to, who is entitled to protections under the ADA and the MHRA. And I will say, I know we're going a little bit sort of out of order. It might seem that way, but there are so many moving pieces to this analysis as well. And Erik and I have tried putting this presentation together in different order a couple times to try to hit all of those points before giving it to you as sort of a step-by-step process. But it's a bunch of, determinations that need to be made that come and intersect in the reasonable accommodation process or interactive process. So we're backing up a little bit to whether an individual is a qualified individual with a disability. So this is sort of a threshold issue when we're thinking about what an employee or an applicant's entitled to under the ADA. But in addition to having a qualifying or a disability under state and federal law, employees must also be qualified. So that means that these individuals have the requisite skills, experience, education, other job requirements for the position that they are involved with, essentially for purposes of the interactive process. So the protections of the ADA, the MHRA only apply to the qualified individuals with disabilities in terms of, the individual or an employee is not necessarily entitled to a reasonable accommodation for a position that they otherwise couldn't hold because they lack a certification or they lack the skills or experience to have. So the key here, though, is that is related to the essential functions of the position. So let me back up a little bit here. Or actually, let's go to the next slide because I think we dive into a little bit more here. So the baseline for reasonable accommodations is that they help a qualified individual perform the essential job functions for their position. So it is important, I think, to establish what a job's essential functions are to help guide both the employer and the employee through the interactive process. in terms of identifying a reasonable accommodation. So the essential functions of a job really go to what the job's purpose is. What are the key elements of this position, the key responsibilities, duties of the position? Because these are the elements that reasonable accommodations are going to be designed to help the employee do, despite any mental or physical disability. So a really helpful tool for this is to establish a job description for positions that employees have within your organization. And the more specific that these can be, the better, including sort of the social elements to this as well as physical elements. Are employees expected to meet with clients? Do they need to multitask on a regular basis? Is it a fast-paced, high-stress environment? These types of elements go directly to issues that we often see mental illness and mental disabilities affecting in the workplace. So if you've been able to establish that these elements of the job, being able to handle these functions of a job are important, then that can help dictate how the interactive process goes in terms of whether you're able to accommodate an individual coming into that position, despite any limitations that they might have related to those elements. A really big one that we've seen recently, it relates to remote work, and especially when it comes to mental health. I've worked with a lot of clients with employees that are requesting more extended hybrid arrangements or fully remote work arrangements due to a mental health issue. And in those cases, one of the first questions I ask is, what does your job description say? Is this a fully in-person job? And if it's not explicitly stated, how do we establish that the in-person element of this really is key? Because those, really delineating that up front is helpful to figure out whether an individual can be accommodated or not through the process. One other note here, employers aren't required to eliminate essential job functions as a reasonable accommodation. So if there is a piece of a job that's very, very key, like imagine for a nurse, maybe being in the hospital doing patient care is a really key function of the position. A fully remote work schedule might require the employer to eliminate the actual patient contact element of that. The employer is not required to make that type of accommodation. The essential functions of the job don't need to change for the reasonable accommodation process, but it's important to have those established in advance to the extent possible. Next slide, please. Okay, so we've talked a lot about the interactive process already, but we wanted to also just sort of lay it out on a slide for you to get an idea of those steps in order. So one, we just talked about determining the job's essential functions is a key first step for the employer in the interactive process, again, to figure out what accommodations are needed to help the individual perform those functions. Next is establishing the actual limitations of an employee related to the job or an applicant to figure out how a mental health issue or another concern might impact their ability to perform those essential functions. And then we're into exploring what accommodations might be available for the individual. And for that, I believe I'm turning it over to Erik to talk about reasonable accommodations more specifically.
Yeah, thank you. Before I get to that, there's a question that's been posed that I just want to address before we kind of move away from this area. And the question states, what if you've been working with an employee for months because the job is not getting done and there are lots of errors, but the employee has not requested anything or given us any indication of how to help them succeed? We know there is a diagnosis. So it's funny that you mentioned this. one of Liz and I's colleagues came to me with a question pretty similar the other day. She's working with an employer who has an employee, and there's been some rumors of mental health challenges, and the employee has sent some emails that are just sort of frankly bizarre and are not in the context of work and really don't make a lot of sense. And people are actually wondering if that's a manifestation of mental health issues. And so in response to that, but also in response to the question you posed, my advice would be, if you already know that there is a diagnosis, presumably a mental health diagnosis, I would go ask the employee, is there anything related to your condition that is causing this problem? And I would get on the record that you have done so. And I will tell you that with regard to this situation that involves our colleague, they are going to do that. And the response is going, and the plan essentially is going to be, is there anything that is, causing these problems that's related to your condition? Do you have a condition? And if the answer is no, then it's going to be, okay, well, your work is not up to par and we're having these problems with you. And this is what we need to talk about. So if I was the person who had written this question, I would go to the employee and say, hey, is there anything here that we need to discuss that this is, that this is causing the problem? Because you're not, you don't ignore the problem. It's not going to go away. It's not going to get any better. So definitely ask the employee in obviously a sympathetic and empathetic way and setting about it, and make sure you document that you have done so, because you have just started you have just at least potentially started the interactive process here. And you want to make sure that you have a record of that if down the line things go sideways and that becomes an issue. Okay, let's go to the next slide, please. Okay, so exploring reasonable accommodation. Reasonable accommodation, you can see the definition up there. It's a change to the work environment or the job that permits someone to participate in the job or the application process, to do the job's essential functions, or to enjoy the benefits and privileges of the position equal to those benefits and privileges employed by those employees you have without disabilities. Equal to, not superior to. Both parties, again, have to participate in the interactive process in good faith and provide relevant information during the process. So, Liz and I predominantly work for employers. It's not enough for an employee, sometimes this happens where an employee says, hey, I've got this issue, I'm having a problem, I need help. Often they don't often use the phrase reasonable accommodation. If employer in good faith goes to them and says, hey, okay, we want to participate, we want to try to help you, tell us more about your situation. Employee can't just shut down. Employee can't just say, hey, I'm having this issue and I need you to do X. The interactive process is just that. It is interactive, meaning both of us are providing information and communicating, and it is a process. It is an exchange of information, so both sides can figure out what's going on. And you'll note there the last bullet here about the employer being able to choose various effective accommodations. So it's obviously to be a reasonable accommodation, if there is one possible, and sometimes there isn't, it has to be effective. It has to solve the problem. It has to allow the employee or the applicant to participate in the job. So let's go to the next slide and look at some things that can be potential reasonable accommodations for employees with mental health related disabilities. Altered break and work schedules, letting people take time off even if they don't have accumulated leave for therapy appointments, or to give them a break during the day in addition to those they may already be entitled to, so they can do whatever they need to do to keep themselves right and able to do work. Physical changes to the workplace or to work equipment. Some people, because of their mental health issues, need, it's different. We talked about concentration and the inability to concentrate as a major life activity being implicated. Something like a room divider, soundproofing, something that, cuts down on kind of the visual clutter of an office, or a quiet space or a quiet work environment can be a reasonable accommodation. Changes in supervisory methods for somebody who has ADHD, written instructions provided where normally they're not, or if somebody, has issues with processing. And we all know that people learn differently. Some people are visual learners, and writing, it doesn't work for them. So the converse of what we've got here, verbal instructions instead of email. Let's go to the next slide, please. Some additional accommodations, specific shift assignments that allow an employee perhaps to continue with therapy or continue seeing a mental health professional, or some people are better, their mental health related condition may mean that they perform better at certain points in the day. Liz talked about working from home and remote work as a potential reasonable accommodation. I actually read a case recently where the employer wanted it was a physical disability where the employee had really bad allergies, and the employer wanted to reassign the employee to work from home, essentially permanently, and the employee didn't want that. So it's kind of a contrary to the usual thing where the employee is usually trying to get increased rights to work remotely or work from home. Changes to workplace policies and procedures, you have to be flexible. You can't have a one-size-fits-all policy about these types of things. In and of itself, having a one-size-fits-all policy, I think under certain circumstances, could violate the ADA or the MHRA. You can see here one other reasonable accommodation: using accrued paid leave or giving additional unpaid leave for treatment or recovery. I will tell you this latter one, unpaid leave as a reasonable accommodation. I believe the legal term for that is minefield. If you put a gun to my head and said, find me a case that says that unpaid leave is not a reasonable accommodation, I could find you that in probably about 5-10 minutes going through my materials. I could also find you cases that say it is a reasonable accommodation. So unpaid leave is it can't for purposes of this presentation, just know that it's out there as a potential reasonable accommodation, but it's going to be something that you're going to want to talk to somebody like Liz or me about. Another potential reasonable accommodation here: reassignment to a vacant position, if that is appropriate for the employee as well. All right, we had talked earlier about the undue hardship defense for employers. Let's go to the next slide and look at that briefly. So you can see here what the undue hardship defense is. It's something that fundamentally alters the business, or it's unduly costly, extensive, it's substantial, or it's disruptive. And those bullets and sub-bullets there are what courts look at. The nature and the net cost of the accommodation, the employer's financial resources, how many employees do you have, where is it, the employer's operation, and if it's a specific facility, the financial resources of the facility. I had a case a couple of years ago where I was representing an individual who had some anxiety issues and needed additional time off, and the employer wouldn't give it to her because they said it was an undue hardship. And the fight was whether they had the resources to do it. And this was a $1 billion multinational company. And so in my filings with the Maine Human Rights Commission, I think I went onto the Wall Street Journal's website or something and talked about, the hundreds of millions in revenue that they had made over the prior year and how many employees they had worldwide, and all these factors that show that they were, a financial behemoth and could easily have given my poor client a couple more weeks off. Their lawyer, who was a very, very good lawyer, pointed out every time I would do that we weren't talking about the company as a whole. We were talking about their small little outpost in, I think it was Chelsea, Maine. And so it was quite a lively discussion about that issue. Let's go to the next slide, please, and we'll finish up on undue hardship. The employer bears the burden of proving an undue hardship defense in an MHRA or ADA case. It is not an undue hardship to reallocate some of the employees' work duties to others. However, it is an undue hardship if the reallocation makes employees work longer and harder. So that is another thing that we thought about in this case. There was my client would say, hey, we worked 40 hours a week. There were long stretches where we were not doing, we didn't have work. We would just sit around and, we didn't have work to do. The other side was saying that, hey, you wanted this extra time off for your disability, and we were going to have to give your duties to everybody else. They would work longer and harder. That's prohibited. So that's generally where the fight is. Okay, let's switch gears just a little bit on the next slide and talk about retaliation, which is a pretty simple concept. don't retaliate, just like in any other sphere, where, you know, if somebody made a race-related discrimination claim or somebody said that they were being sexually harassed, you wouldn't retaliate against them for for letting you know that there's a problem. You cannot retaliate against an individual who requests a reasonable accommodation. So there's a couple of sort of big bright line examples there. Adverse employment action, i.e. you're fired because you asked for a reasonable accommodation. Or Liz mentioned earlier about trying to get the employee to see a different healthcare provider. You can't do it just because you don't like the first answer. So this is that could be potentially an example of retaliation, sort of harassing the employee to provide more and more after they've already done enough. All right, let's go to the next slide and talk about some kind of common issues that employers face here, and strategies in dealing with employees with mental health disabilities. So discipline is one. I mentioned earlier that a lot of times in the context of dealing with other employees or potentially your customers, somebody who's having mental health issues, that might be problematic. Obviously, you don't want an employee cussing out their coworkers or one of your clients. Disciplining them, though, you're in that circumstance, you could potentially get the argument, hey, you're disciplining me for the effects of my disability. You also have to look at, notwithstanding that the employee's behavior may be sort of strange, are they doing their job? Are they performing their core essential functions that Liz mentioned earlier about, that's something you have to drill down on, especially in an ADA situation. And Liz had earlier talked about people being regarded as disabled or being considered to be disabled because they have a record of their disability. That's the sort of stigmatization and stereotyping that has been historically associated with mental health related disabilities. So if we go to the next slide, you also need to look at, doesn't the employee's behavior pose a threat to their safety or the safety of other employees? You don't have to give a reasonable accommodation if the reasonable accommodation is going to harm the employee themselves or cause harm to other employees. And that kind of dovetails into the last bullet on this, which is there a threat of workplace violence? That's always a concern in a lot of different atmospheres, but here in particular. So I'm going to throw it back to Liz, and she's going to talk a little bit about some suggestions and best practices when it comes to working with employees that have mental health issues.
Yeah, so I think probably every presentation I do, you'll hear me talk about policies at one point or another, but no exception today. So I think one of the best initial defenses that an employer can put in place is having great policies that apply to their workforce. So prohibitions on discrimination and harassment, and making sure that those include prohibitions on discrimination and harassment for mental disabilities, as well as physical and other protected classes. Having your reasonable accommodation request procedure in writing can be really helpful. That way employees can reference that to know who to talk to, and what, whether it needs to be in writing or verbal. And we already talked about sort of the flexibility of that process, but laying it out can be a great resource for employees. Having anti-retaliation policies in place, as well as workplace violence policies in place. Again, I say that not to suggest or in any way insinuate that folks with mental health issues have a workplace violence problem that's any different from anybody else, but it's one of those policies that we're more and more encouraging for employers to have in place, just to address issues if they arise and have a response prepared for situations. Education on policies is also really important. A handbook doesn't do a whole lot of good if employees don't know how to access it or have never seen it before. So definitely would encourage you to include that in your orientation and onboarding process, redistribute it on some sort of regular basis, and have employees sign acknowledgements stating that they've read it, they understand it, and that they know where to go with questions on it. And for anybody specifically who's handling accommodation requests or engaging in the interactive process, it's a great idea to have those folks go through some additional training, whether it's internal or external, And at the very least, understanding what your organization's policies are so that they know how to comply with those policies and handle those requests in a consistent, efficient, and non-discriminatory manner. I know we're at 12, but I'm going to keep going just with our last couple slides here. So I appreciate everyone hanging in there with us. Another sort of best practice is documentation. And Erik mentioned this briefly earlier, but documenting accommodation requests and documenting responses from the organization, the success of those accommodation attempts, any employees, declining an accommodation offer, having everything, essentially everything related to the interactive process in writing, super helpful, both so that, there's continuity within the organization of what's been done, what can we try next, and, what does the future look like, as well as defending a claim. If there ever was a claim that, my employer failed to accommodate me, you would have a record that this is all the steps that we took and we did our best to do so. With all that documentation and any medical records that your organization might get in relation to an accommodation request, those should be kept, any medical documentation should be kept separate from the personnel file in a sort of confidential place with very limited access, only those people with a need to know. And I think more generally, keeping in mind that with regard to disabilities as any medical issue, keeping that information to those with a need to know is a very, very important practice, both to avoid discrimination, harassment issues, because it's more difficult to argue that discrimination, harassment occurred if the individuals involved didn't know about it. As well as to avoid any stigma or any inadvertent different treatment based on individuals' understanding of an employee's situation. That brings us to our last slide for today. Some more best practices. Cultivating a supportive environment. This is a huge bullet with a lot to it, I think, but generally, taking steps to understand these issues and relay to employees that you are an organization that understands, that supports, that can be, a resource for employees that are going through mental health or other issues. Whether it's including information in a newsletter or acknowledging mental health awareness weeks, providing support groups, anything that you can do to sort of reduce the stigma and the aloneness that individuals feel who might be going through this issue, and relay that perspective to employees so that they feel comfortable being able to make an accommodation request rather than going through the motions and perhaps struggling at work, because that's not great for everybody's productivity. So being a resource for your employees to open that dialogue. On this point, it's really great to have managers also be sort of briefed on efforts and supportive of efforts by the organization, because the manager buy-in, so to speak, helps encourage other employees buying in and understanding these issues and responding to them. Another point on this bullet would be being really understanding of what employees' needs are. And when I say that, I'll preface that by saying I think nearly every employee who's going through a mental health issue does not want to be. They don't want to be experiencing these issues that have, result in them having these discussions with the employer. They'd probably prefer not to be on leave. They'd probably prefer just generally not to be handling what can be really difficult issues. I think it's great if employers and HR professionals can, have that sort of in back of mind when dealing with these, when dealing with potential accommodation requests, especially related to leaves and returns from leaves. Just being sensitive about what the circumstances of employees are dealing with, I think is important to both reducing that stigma and sort of developing that supportive environment. Lastly, providing resources to employees to help with mental health issues. EAPs are great. Again, communicating the contact information and enrollment information is really helpful so that employees know how to access those programs. Providing information about counseling services, as well as flexibility for employees to make their mental health professional appointments, their therapy appointments. being supportive in that way, I think can go a long way in terms of, helping employees stay with the organization, to the extent that they're able to and be able to thrive there despite going through what might be a difficult mental health issue. But I think putting in that investment as an employer can really have great, results in terms of retention and, again, being a supportive place to work for your employees. With that, we'll take any questions. I think, Erik, unless you have anything else to add, or
I see that we have one additional question in the chat box, which I'm happy to.
Yeah, go for it.
So the question is there an adult 504 plan that an employee or applicant may provide to help understand specific accommodations? I think that's a reference to IEP plans. I don't do that type of work, but I know enough about that to kind of issue spot to that level. Yeah, it's sort of a doctor's note. That's typically a lot of times what, you're as an employer, if somebody comes to you and says, hey, I've got X problem, whether it's a physical or a mental disability, again, unless it's obvious, unless, we use both Liz and I use the broken leg example, because that's a big obvious thing when you see somebody with a cast on crutches. When you don't have something like that, when it is something that's more subtle, a doctor's note, oftentimes, and not necessarily a doctor. I mean, it can be any kind of a healthcare provider, LCPC, LCSW, anything like that. But something like that talks about, what the employee's diagnosis is and what the accommodation is, and sort of links A to B, is very helpful, and generally can be required by an employer.
Yeah, and I'll add to that. I think, at least in my experience, sometimes there is a little bit of a disconnect between the information you might get from a mental health provider versus how does that fit into our workplace. And again, just understanding sort of the ability to really act on the request for the information that you need as an organization to help figure out what accommodation is needed. But especially, when we're talking about difficulty socializing, concentrating, focusing, it can be difficult sometimes on the first go around with the doctor's notes from the professionals to really get that information specific to the position that the employee has to.
And then we have one other question, which I'm not sure is really directed to either you or me. It's probably more of a Leah question. Leah is our marketing person who's been behind the scenes and has been moving the slides. Will we get a copy of these slides? I believe yes. The answer is yes. And if you don't, Liz, my email address and Liz's is on, I'm epeters@veril-law.com. She's ejohnston@veril-law.com. Reach out to us, but I think we will be providing them to everybody who registered.
Yep.
So, yes, Leah is confirming that we're right. Okay. So I think that's it. I want to thank everybody for attending. It's fun for both Liz and I. And again, if you have any other questions or follow up or anything of that nature, please don't hesitate to reach out.
Thank you.